registering a trademark are governed by the laws of the country in which the registration application is made, and these rules differ from country to country. Thus, companies must submit application forms to the central office of the countries in which they intend to operate, in line with their established procedures. Now, despite occasional differences, many territories offer vastly similar processes and protections, largely underpinned by international intellectual property agreements. Here are just some of the differences that will be encountered when registering a trademark in different territories. United States of America. America is one of the busiest territories for trademark registrations in the world. U.S. law stipulates that in order for a mark to be registered, it must first be used in commerce. In addition, once the mark is registered, you are under an obligation to maintain use of your mark if you intend to keep the brand active and avoid revocation. Ownership, therefore, does not rest merely upon registration, but hinges upon the actual use of the brand. Italy. In Italy, a non-registered mark is still protected, though the extent of this protection is lesser than afforded to a registered mark. Pursuant to the Civil Code, trademark registration does not nullify the rights of those who have used it up till this point. Under certain conditions, someone who proves that they have previously used a mark that another is seeking to register has the right to continue to use it, provided this is within the geographical and general limits of its previous use. USA also has similar protections. China. Chinese legislation, on the other hand, only grants protection for marks when they are actually registered. The previous use of a brand, therefore, does not confer any rights of priority. Furthermore, as in the USA, Germany, France, and Japan, the first to file principle applies. Whoever files a trademark application first acquires the ownership rights. In China, as well as other territories following the first to file principle, it is essential to register well in advance of the effective start of business activity in order to ensure such use is protected. Moreover, due to the lengthy waiting periods to obtain trademark protection, anywhere from 18 months to 3 years, and the fact that protection only subsists once registration has been obtained, it is advised that businesses wishing to register a mark in China allow plenty of time for protection to arise before entering the market. Now, additionally, Chinese law requires a translation if the mark is in a foreign language. When doing so, it is also strongly advised to register a corresponding version using Chinese characters, both to avoid risks of counterfeit competitors and excluding your mark from a share of the market and therefore potential customers. Unlike many other systems, China also requires that a separate application is made for each class of goods or services the trademark is to be registered with regards to. This requirement increases both the time and expenditure for registration of a mark. Brazil. Brazil also requires that each registration in a class of goods or services to be completed on a new application form, again increasing time and cost expenditure. Additionally, Brazil adheres to the first to file principle, meaning registration of the mark is necessary for protection. Further requirements of trademark registration in Brazil are that the mark must be capable of being visually perceptible. Therefore, unconventional marks, such as sounds and smells, are incapable of registration in Brazil. Now, Brazilian law, just like UK and EU law, also stipulates that if a mark has not been put to bona fide use within 5 years of registration being granted, the mark may be subject to revocation. India. In India, marks which are considered by the authorities to be contrary to public order or good morals are deceptive or offensive, and they're not capable of registration. Many other territories have such a clause, including the United Kingdom. However, Due to the multitude of religions and beliefs present throughout India, it is advisable that businesses wishing to register their brands in this territory carry out prior analysis in this vein. If, upon publication of a registered mark, a person wishes to file for opposition on any grounds, they must do so within 4 months, with the opportunity to apply for a 1-month extension when it comes to supplying evidence of the reason for opposition. This potential extension on the time for opposition means that the time taken to register a mark may increase. The USPTO. The EU registration allows for a trademark to be registered in all EU states, current and future, with one single application form and one set of fees. The European Intellectual Property Office, EUIPO, receives applications from all over the globe and, upon registration, allows trademark holders to exercise their exclusive rights in all 28 territories. The advantages in pursuing an EU registration with regard to time and money and expenditure need not be explored any further. WIPO. Wider than EU registration is the World Intellectual Property Office International Registration. Referred to as the Madrid system, this registration process enables businesses to file one international application from their country of origin in one language, paying only one set of fees, yet the mark is capable of being registered in any of the 104 members which are party to the Madrid Agreement. This international registration process entails access to the same protection that the laws of member countries confer upon national trademarks. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Jonathan Morton, and I'm a U.S. licensed attorney. I'm a partner with the law firm of Morton & Associates and a member of the TradeMarkers Network. Thank you for watching.